This conference will now be recorded.
Okay, so I first of all I welcome everybody for today's monthly meeting of WRC RERA study group. And today we do have an eminent speaker, Advocate Mithil Vinod Sampat. Before I request CA Digip Agarwal to introduce our today's eminent speaker, I would again like to make a request to everybody in the group to kindly come forward and volunteer yourself presenting any topic related to RERA in our monthly RERA study group meeting. So over to you, Dilip sir.
Yeah. Thank you so much, Ji, for giving this opportunity. And I am really privileged to be part of the RERA study group at WRC. And this is the platform where frequently we are meeting in different way. This is the monthly meeting. This is one meeting every month. And then we had been part of frequent meetings regarding the WRC manual on RERA, MahaRERA rather. And I'm saying
Correct.
proudly that I'm also this. Most of us are part of this. Most of us, I'm saying,
Yes,
including
yes.
the today's speaker.
Speaker.
And therefore,
Correct.
I have the privilege. Yeah, today's speaker, yes, and he has volunteered to review. I could see that day the kind of energy, time, and management
Yes,
from
yes,
Mithil sir.
yes,
He could choose
yes,
around 7 topics. I
yes,
will review. I will review. That is not a small thing. It shows the kind of passion, knowledge, and commitment. And this kind of person is with us. And
yes.
I can say Mithil does not require any introduction at this platform because he's very new now. Not new. He's very old now. So
Old,
many times he
known.
has appeared with known face, but some of members may be new at this time. Therefore, as a formality, I have to introduce him, and time will come. Like Vinod Sampat Sab, I can see more rigors in Mithil. He can spread his experience, knowledge, and the smile throughout Maharashtra. And really, it's a kind of privilege that this platform has given us advocate, kind of friend, younger friend, and then we can also live life as smiling face, and that is very rare in the profession. Everyone is tense. अभी comply करना है, अभी ये
Yes,
काम करना है, कल hearing है, उसका तैयारी करना है, but he is always smiling, and that itself
yes,
is a good introduction. A part of that, some of the achievements, he is specializing in the consumer laws, real estate sector, cooperative laws throughout Maharashtra. And he's also co-authored, as I said, in the Maharera book at WRC platform. He has appeared for various arguments at different platforms, including Supreme Court. And he judging the academic competitions at various law colleges at Mumbai, including National Law University at Mumbai. He has delivered a series of lectures that exceeding a century. That is what I can say. He is very passionate to share his knowledge and experience at different platforms, including the MBA colleges, law colleges, and other platforms. He is a faculty at various renowned organizations like MCHI, CREDI, Rotary Club, Law, Law Topus, Plea, E-Justice India, ICI, as well as YCWA, UNICEF, etc. In the days come, he will cut off all those things because he will be known as delivering lectures at various platforms, renowned platforms. He's a
correct.
faculty for diploma courses for various organizations, and he's quoting in newspapers also. This is the kind of experienced speaker we have today. We should take maximum advantage and make it interactive. I request all the members, please start your video and don't keep behind the bars. And if you can keep yourself behind the video, then possibly you might be missing direct interacting with the speaker. He will be loving to interact with you in between whenever you feel. you can interact, you can raise your hand, virtual hand. Our Sumit ji will give you opportunity to interact with the speaker. That will be more, because this is the study group program. It is not some of the seminar where the only speaker will speak and others will listen. At the end, people can raise some questions. But here it is study group. Anything and everything you can ask from him, other than the topic which is delegated to him. Because I know him personally, that he is very much through about various aspects, even of RERA as well as consumer matters. Okay, now handing over, Mithil ji, over to you.
Thank you, sir. Thank you for that very generous introduction. I will just share my screen. Is my screen visible, sir?
No.
Not yet. Not yet.
Not yet. I will just do it again. Now?
Yes, but it is still dark. Not, I think it's visible.
Not visible to me, sir. Sumit ji, I don't see any.
Not visible. Not visible.
Window away. Give me just 1 second. I think something is giving me an error.
Okay. I'll also simultaneously call the technical help. Yeah, I'll call the technical help simultaneously.
Sumit sir, क्या हुआ?
Sir, the speaker is not able to share his screen.
Can I share the error message?
विनोद सर को दे देना सर, विनोद सर को.
जी. मिथिल विनोद संपत.
विनोद सर आप स्क्रीन शेयर करिए.
I'm sorry?
आप स्क्रीन शेयर करिए सर.
जी 1 सेकंड.
वहाँ पे जो कैमरे का माइक का ऑप्शन, स्क्रीन शेयरिंग का भी ऑप्शन है, बाजू में आप क्लिक करेंगे तो आ जाएगा.
I'm sorry, can you repeat, sir?
सर इधर नीचे देखिए, माइक का, कैमरे का और स्क्रीन शेयरिंग का ऑप्शन है, तो वहाँ पे क्लिक करेंगे ना तो जो आपका विंडो इसको क्लिक करिए और शेयर करिए.
बटन तो दिख गया मुझे. It's like
हो रहा था, आपने शेयर भी किया था.
I was getting some error that some window is preventing from sharing. So it was saying that it's trying to share, but something is preventing.
वापस से दिया आपको, ये देखिए वापस से दिया मैंने आपको ऑप्शन.
This is like the 7th to 10th time I'm trying. I'm still not coming. Do one thing. I will leave the meeting and I will just join again in 1 sec.
Sumit, maybe we can start without screen also, because we know Mithil Bhai must be having his presentation ready.
Atul ji, it will be more lending to the participants. Let him rejoin. Yes.
Yeah.
Give me
please.
Okay, it's your call.
उन्होंने पहले शेयर किया तो पूछ रहा था, जस्ट अपने सेशन स्टार्ट होने से पहले.
अच्छा सुमित जी, मेरा एक छोटा क्वेरी आपसे. अभी जो सीए के फॉर्म 3 and 5 जो है, जो कल हम लोगों ने डिस्कस किया, वो तो ओल्ड वाला जो है वही है ना फिलहाल? तो
अभी तक तो वही है, अभी तक ये नहीं.
Share screen access, please.
Yes. मिश्रा जी, हेलो.
हाँ सर बोलिए.
हाँ, उनको एडवोकेट मिथिल संपत को दीजिए ना ये स्क्रीन शेयर का एक्सेस. नितिन सर, आपको स्क्रीन पे ये आएगा, यू आर द प्रेजेंटर नाउ.
I have not got it still now.
वो लोगो इनेबल हो चुका है, अपना म्यूट अनम्यूट के बाजू वाला जो रहता है वो.
I can see the button, but I'm not able to click it. Yes.
Okay.
Now is my screen visible, sir?
Yes, it's visible. Yes.
Full screen is visible, the slideshow?
Yes, sir.
Yes.
Yes, slideshow is visible. Okay.
So my sincere thanks to the study circle at WIRC. My sincere thanks to CA Sumit Kapure for inviting me. My sincere thanks to CA Dilip Agarwal for the very generous introduction. My dear friends, I will come straight to the point. First of all, who can face issues in the real estate transactions? We have types of disputes where it is allottee versus promoter, Other types are allottee versus the promoter and versus the agent. Another category is allottee has a grievance against the promoter as well as the society. You see, it is very common, my dear friends, that society or committee members or chief promoter are hand in glove with the promoter. So society is supposed to be on your side, but it is not, and allottee has a grievance. Examples of these types of dispute is when society deliberately accepts faulty accounts, that they are not audited accounts or they are wrong accounts. Society is supposed to receive more accounts. Then deliberately promoter is not forming society to enable him to continue receiving amounts from the members, from the flat purchasers. Then another situation, which is a very common thing, is that society is deliberately not taking conveyance, and as a result, allottee has to file a case against the promoter and the society. And last but not the least, redevelopment disputes are where the allottee can have a grievance against the promoter as well as the society. Also included in consumer law is if society has a grievance against the promoter for any of the aforesaid. And also included in consumer, my dear friends, promoter is not in the picture, but allottee has a grievance against the society. And though that is not within the purview of RERA, it is my duty to share with you that allottee as a member of society can take the society to the consumer court. And lastly, my dear friends, promoter can also have grievances, but promoter cannot pursue it under consumer law. I will show you how. Under consumer law, my dear friends, promoter is not allowed to file a court case. Under consumer law, promoter can only defend, can only appeal, and can only execute the consumer court case. So consumer is a one-sided law. It is a one-way street. And that is why I will speak more from the allottee's point of view. Just how promoter is not allowed to pursue under consumer, similarly, little restriction is there on allottee also. Under consumer, commercial purpose is not allowed. So you see, my dear friends, under consumer law, only the person who is a consumer or grahak who is going to enjoy or consume the goods can come under consumer law. The opposite of consuming is commercial. So even if you are an allottee, but if you are some kind of a commercial purpose, then you cannot come under the consumer law. So what are examples of this commercial purpose? Many times the flat which the allottee purchases, that he purchases as an investment flat. He buys at a feasible square foot rate, prices will rise, and he will sell off that flat. So that is his resale investment flat, that he is buying not for occupying the flat. He is buying not for living there. He is buying not to enjoy that flat. He wants to enjoy the profit from that flat. So selling flat, resale flat at a higher price, that is not allowed. And also another type of example is that many times flat is being purchased only to give it on rent, only to be subletting it to some tenant or some person. So many times in the course of the transaction, my dear friend, suppose promoter is dealing the possession. So allottee inevitably ends up sending messages or emails that, dear promoter, please deliver possession. My buyer is getting anxious. Dear promoter, please deliver possession. I want to give it to my tenant. So if promoter can show these kinds of communications, it is better you get in touch with a lawyer before filing a court case or some legal professional before filing a consumer court case, because you will have to send some messages or some emails to rectify this situation. If promoter can show that this is a resale or it is a subletting wala flat, then consumer court will be reluctant to grant you relief, and that is why before the consumer court case, the allottee should send a message. Earlier, it was for resale and subletting. Now I have had a bona fide change in intention. Now I do not want to sell or sublet it anymore. Now I want to live there. I want to occupy there. So allottees are not allowed to do commercial purpose in the nature of resale and subletting. And if correspondence, if facts of the case discloses this, then you just send a message to rectify the situation. Earlier it was for subletting and resale. Now I don't want to sublet and resale anymore. Similarly, about commercial purpose, commercial flat is not allowed under consumer. Commercial flat, you buy an office space or a shop, that can be done only if the elements of self-employment and livelihood are there. So in short, my dear friends, commercial purpose, profit motive from consumer code is not allowed. Resale, subletting and office space is not allowed. With the just exceptions that if it is a sublet and resale, just send a message and rectify the situation. And if it is a commercial flat, you have to compulsorily do self-employment and livelihood to get the advantage of the consumer law. The simple terminology used in consumer courts, my dear friends, allottee is called the consumer and promoter is called the opposite party. Now, my dear friends, what are the various types of grievances which are suffered by the allottees? First of all, project is liable for RERA registration, but the project has not been registered. Then, when project is registered, it is not being updated regularly as is required under RERA. Then some permissions are not in place. For example, construction has started without commencement certificate or aviation NOC is not there, etc. One of the various permissions which is required has not been there. So permissions are not in place. Then some encumbrances are there on the property which have not been disclosed to the allottee. Then monies are being collected by the promoter, but agreement is not being done as per the RERA mandate of 10%. Then you enter into the agreement, but then you will see that the promoter, he has reduced the carpet area. You see that the carpet area in the agreement is much lesser than what you negotiated, what you saw in the brochure, what you saw in the advertisement. So carpet area issues are there. Then when you ask for possession, you realize that the possession is going to get delayed. Then when you now get possession, you see that the flat is changed, the plans have changed, carpet area may have reduced, but even if it is not reduced, the possession has changed or some amenity is not given. Now it is very common that people purchase some particular flat for some particular purpose. It is facing either the road facing or the not road facing, and promoter sometimes changes the allotment altogether. Or sometimes it is a very common thing that people believe in Vastu, and according to Vastu, it is this facing like this, and now plans are changed and it is not Vastu compliant suddenly. Then as a result, you see that the brochure or advertisement was totally false and misleading. It led you to believe one thing, but now that has not been delivered and that has become a false or misleading advertisement. Then when you take possession, you realize that construction is terrible. There is leakage, plumbing is breaking, doors and cabinets are breaking, walls are cracking, etc. So the defect is there in the construction quality. Then when you seek clarification from him, turns out he is not disclosing the accounts, he is collecting money, but he is not providing any statement of accounts, or he is not providing you details that what material was used, etc. So you seek clarification from him and he does not revert to you. Then you see the agreement and you realize that the agreement is totally partial and unfavorable to you. So you have signed terms and conditions in which you have sacrificed your rights. So there are one-sided agreements. Then builder is not forming society and is not handing over the conveyance. When you ask for conveyance, you find out that his title is defective. And when you complain about all this, the builder will terminate your allotment and he will cancel your booking unilaterally. So broadly, these are the types of issues which the allottees face. And when allottees have issues, when these clients who are allottees have issues, they have one of two requirements. Either they say we want to stay in the project, or they say we do not want to stay in the project. So it is like, I want to stay in the project, even though he's doing wrongdoing, I like this flat, I want to stay in the project. So you get me the relief that I want, you get all the wrongdoings removed, etc. I want to stay in the project. Or they say, I am fed up with the promoter, I am fed up with the project, I want to exit the project. And in both these cases, stay in project or exit project, both these cases, allottees want compensation. Now, as professionals, what we can suggest to the allottees, we can suggest a threefold approach. Number one, apply to RERA for the RERA penalty. So I am sure that RERA penalty provisions my learned friends must very well be aware of. So I will not go into much detail into RERA provisions. I will spend more of my time apprising, my dear friends, of the consumer provisions and comparisons with RERA. So step number 1, professionals, step they can take to give relief to the allottees is get the RERA penalty upon the promoter. Number 2, step number 2 or option number 2 which you can take, investigation at this new authority called CCPA, which I will explain in the next slide. And number 3, file a case, litigation, file a case either in RERA or in consumer. So at this point, my dear friends, let me clarify, you can do 1 and 2 together. File RERA complaint for penalty also, write to CCPA also, that dear CCPA, please carry out investigation. It is only number 3 that you have to choose between 1 or 2. So you cannot file 2 cases, one at RERA and one at consumer court for the same reliefs. I will give you an example. Suppose you have paid 10 lakhs for your flat and you want refund. You cannot file one 10 lakhs case in consumer and one more 10 lakhs case in RERA. It cannot be the case that you will succeed in both the cases and for 10 lakh principal you will receive 20 lakhs compensation. No. What the Supreme Court has said, something called doctrine of election. You elect which of the 2 remedies that you want. So you go either to consumer court case litigation or you go to RERA court case litigation. But it is only for one cause of action that you cannot go to both. If you have 10 grievances, go 5 in RERA, 5 in consumer. So that is the principle. It's not that you cannot go in both simultaneously. It said you cannot go in both for the same cause of action. If you have separate causes of action, you are free to pursue them in the different courts. You can pursue 5 here, you can pursue 5 there. So broadly speaking, these are the remedies professionals can give to the allottees. Complaint to RERA for penalty, complaint to CCPA for investigation, and the court case. So my dear friends, what is this CCPA authority? Just how RERA is the regulator for the real estate field, like that only CCPA is the regulator for the consumer field. Think of CCPA like a public interest litigation authority. It protects not you and me privately, not you and me personally, not you and me individually, but it protects the allottees, it protects the consumer as a class. As a class, it protects consumer as a class. So for example, a class of allottees or a class of allottees which can also include the legal entity, namely the society. So that forms the class of consumers. So wherever there is wrongdoing in the consumer field, CCPA can do investigation. My dear friends, for carrying out this CCPA's investigation and penalty job, CCPA has incredible powers which RERA does not have. First of all, CCPA has an in-house police department called Investigation Wing to carry out the raids and search and seizure. Can you imagine the CCPA authority is given in-house police department? Now let me give you one small background that what is the background of this consumer field and why it is helpful to protect allottees. You see, my dear friends, this consumer field is not made only for real estate. Consumer field is made for the whole of the consumer industry in the country, and allottees and real estate forms a part of this consumer industry. So when the government and parliament, they have sought to strengthen the consumer industry, invariably and inevitably they have also strengthened the allottee by giving these strong provisions. So my dear friends, the main job of the CCPA authority is to carry out investigation and if required to carry out raids, search and seizure to determine and collect evidence, and if required to impose penalty. This how RERA can impose penalty, even CCPA can impose penalty. To carry out its investigation, CCPA can summon anyone. It can summon anyone to give information and to collect evidence from them. Government authorities and third parties can also be summoned, and there is no restriction. In the comparison with RERA, I will show you how RERA is only allowed to carry out investigation between the stakeholders, the allottee, promoter and agent. That is the only scope which RERA can do the investigation under. Then CCPA can engage technical experts for their consultations for their technical issues, for their opinions. It can engage architect, engineer, chartered accountants, advocate, contractors, anyone to determine what is their opinion in any given case, to determine the facts of the case. And if the CCPA wants, it can send the goods to the laboratory for testing. How good is the construction, whether the materials are really inferior, etc. So investigation and raid and search and seizure and penalty is the main job of the CCPA. You will ask me question, what kind of orders can the CCPA pass? And I will tell you, my friends, section 19 gives uncontrolled power to the CCPA. Section 19 says you fix the wrongdoing in any which way you think fit. So there is no straitjacket formula. There is no restriction. There is no modus operandi. It is totally flexible and totally free hand is given to the CCPA. Fix the wrongdoing in whichever way you see fit. Pass, the words used in the section are, it may pass such order as it deems fit. It may pass such order as may be necessary in its opinion. So unbridled and uncontrolled power is given to the CCPA, which when it is not bound by any formula, it is not bound by any restrictions, it is not bound by any loophole. That is the important part. Now, like I said, my friends, in strengthening the consumer field, inevitably, real estate field, the allottees were strengthened. So for this misleading advertisement concept, CCPA can also look into misleading advertisement concept. Now, you, my friends, may very well be aware by reading newspapers, etc., that misleading advertisements were such a problem in the whole consumer industry in the country that Parliament decided, let us come down heavily on people who are doing misleading advertisements. So for misleading advertisements, even heavier powers are given to the CCPA. So thanks to the broad wrongdoings that were going on in the whole consumer sector, thanks to those wrongdoings, the benefits, the remedies which are sought to curtail those wrongdoings, the benefits even allottees can take. So the stringent provisions will apply to the allottees and promoter also. So what are the provisions and powers of the CCPA in relation to misleading advertisement and real estate? CCPA can say you stop the advertisement for a total of 3 years. CCPA can say pay up to 50 lakhs penalty. CCPA can say go to jail for up to 5 years. And my dear friends, most of these orders CCPA can pass even pending investigation. Investigation is not yet complete, investigation is still ongoing, and yet penalty is imposed, and these are very, very, very heavy penalties. Just how RERA's adjudicating officer has those considerations for granting compensation, similarly, CCPA authority for granting misleading advertisement order, it has to have certain considerations which are very similar to adjudicating officer considerations. What is the size of the population that is affected? For example, it is a phased project. There are 5 phases, 100 allottees per phase. It is in today's modern construction, it is very normal to have even 200 allottees in one big tower. So what is the size of the allottees that is affected? It is a big project, big phase. There are 500 to 1000 allottees that are affected. So that will be taken into account. What is the frequency and duration of this misleading advertisement? So these 5 phase projects was going on since the past 5, 10, 15 years. So it's such a long time the misleading advertisement was making a fool of the public. What was the vulnerability of the allottees? I am getting some error that my network is not stable. If you need me to repeat anything, just ask me to please repeat. I will repeat myself. So next is, what is the vulnerability of these allottees that have suffered from the misleading advertisement? Sometimes they are lesser literate. The projects are constructed in sometimes in such places where the persons, not everyone is very educated. So that will be one consideration, that you have taken advantage of this vulnerability. Another example, even in the metropolis area, in the most hi-fi posh area, the vulnerability can arise from the circumstance that the allottees have paid the full amount, they have paid full or majority amounts, and now they are at the mercy of the builder, and builder is using arm twisting tactics. So the vulnerability of the allottees will be taken into consideration. And lastly, for passing misleading advertisement order, the gross revenue earned by the promoter will be taken into account. Keep in mind the term used here is gross, not net, and revenue, not profit. So there is no need to go into detailed books of accounts that because of this advertisement so much net sales has resulted. No, a superficial summary and overview view will be taken to determine what is the gross revenue which has been generated from this misleading advertisement. Now, my dear friends, to prevent abuse of these raid and the penalty provisions, certain safeguards are given to the promoter. First, there is the rule of audi alteram partem, the right to be heard before passing an order. That one safeguard is given to the promoter. Then in the section 19 and 20, there are express safeguards, which are express defenses which the promoter can invoke to challenge these section 90 and 20 orders. So there are express defenses available to the promoter. Then there is a provision for vexatious search. So if CCPA is carrying out a search and seizure or a raid on a promoter, despite no grounds, despite not having any grounds, then the promoter can sue CCPA that, see, you have done a vexatious search, you have had no grounds to proceed against me, still you have proceeded against me. So promoter can take advantage of this vexatious search provision. And lastly, if the promoter is aggrieved by the CCPA order, he can challenge the CCPA order in the National Consumer Court within 30 days. So this was broadly the CCPA authority, its search and seizure powers and its penalty powers. And I will just repeat myself, this penalty power of the CCPA, it is similar to the RERA penalty power. RERA penalty goes to RERA, not to the allottee. It is not compensation, it is the percentage, the RERA percentage of the cost of the project. That penalty goes to RERA, and even these penalties of CCPA, they go to the government. They don't necessarily comes to the allottee. Only if order is passed for reimbursement by the CCPA, then it will come to the allottee. So coming to RERA penalties, I am very sure, my dear friends, all my learned friends must be aware in detail what are the RERA offences, what are the RERA penalties. These are there within chapter 8 of RERA. I will not go into much detail for that purpose. I will presume that my learned friends are aware of the same. And I will just mention that typically the RERA penalty which is levied like this, it is either 20,000 or 50,000 or usually 1 lakh in a slightly less frequent scenario. Right now, I will talk about the litigation in the consumer court, and after this segment is over, I will come to the analysis between the pros and cons. So now, till now, my friends, we have discussed the RERA penalty, we have discussed the CCPA penalty, which is the consumer counterpart of RERA, and now I will discuss the consumer court litigation. RERA litigation I will not go much into because I am sure you are well aware. So I will show the analysis in the next segment and not the substantive or procedural provisions. I will just show the analysis and comparison. So for right now, let us see the consumer courts. First, I will tell you the general procedure and then I will tell you the extra provisions in consumer. The general provision, the hearing provisions are that limitation period is 2 years given for consumer courts. So from the date of cause of action, the allottees have 2 years to file their court case, and this limitation is not applicable in case of statutory obligations like society has to be formed, conveyance has to be given, etc. At this stage, let me also clarify. There is not any gray area, but there is a slight complication or confusion that clients and laymen are a little confused that when does limitation start in case of delay in possession matters. The principle is very simple, my dear friends. When the flat possession is delayed, the relevant question is the booking, is the allotment still valid, still ongoing, or is the allotment terminated? Limitation will apply, this 2 years limitation for consumer courts will apply only if the booking has been terminated. So for example, because of the misunderstandings and because of the non-negotiable stands of the parties, this promoter sends a letter that this is a termination letter. It sends this letter saying January 2018. So when flat is cancelled, your limitation starts from the cancellation date. But if flat is not cancelled, then the 2 years limitation does not apply. which means that suppose 1980 you were supposed to get possession, but till date there is no termination letter. You can file today 30-40 years later also. So that is the principle of limitation in delay possession, where allotment is still active, limitation will not apply, and it is a continuous cause of action. And where allotment is terminated or allotment is given and you have the grievance, then your 2 years time limit will start from that procedure. So that is the limitation provision. Now, suppose you have filed your consumer court case, there is a provision of deemed admission. Within 21 days of filing, you are supposed to get an admission hearing, the first court hearing, the first court date. If that is not given within 21 days of filing, then there is deemed admission. Under consumer courts, your matter is deemed to be admitted, and you can proceed to the next stage of sending the summons to the builders. Then, when summons are sent to the builders, builders have 45 days maximum to file their reply in the consumer courts. Then builder will file reply, there will be rejoinders, and there will be affidavit of evidence, there will be arguments, and then judgment will be passed. This is broadly the disposal procedure in a consumer court case, and all this is supposed to happen within 3 months. Now we all know RERA court and consumer court both are a little burdened, so this time limit, it is not always easy to adhere to it, but there are some dialogues which we can use in the court to prevent delay tactics. If unnecessary adjournments are being sought by the opposite party, you can use 2-3 dialogues. Like number 1 dialogue, my lord, last chance be given. So don't let him seek adjournment for this purpose again and again, for this purpose, for filing reply, for filing application, appeal, whatever. This should be the last chance. Number 2, impose cost, my lord. If he is seeking adjournment, seek cost. 1,000 rupees, 2,000, even 5,000 rupees cost is granted by the court for unnecessary adjournments. And number 3, get it specified in the Roznama. What is the purpose of adjournment? So many times the juniors come in the court and say, my lord, senior is busy, please grant adjournment. No, you request the court that, my lord, you please record in the Roznama that the senior, this is the reason they are seeking, and this is the ground on which they are seeking adjournment. My lord, kindly record the reason. So get the reasons recorded in the Roznama. One type of adjournment is that senior is busy. Another is that, my lord, kindly grant me a short date. I will file so and so. I will file the rejoinder, application, reply, etc. So get it recorded in the Roznama that adjournment is being sought for so and so purpose. So it can help you in preventing delay. So if adjournment is already granted on that one ground, you point out to the court when the same ground is being used again for adjournment. And no, my lord, they have already sought date and time on this ground, and this should, another adjournment for the same should not be granted. So you can adopt a lot of dialogues to avoid the delay tactics and to ensure that your matter goes on smoothly. So this was the general disposal procedure. Let us talk about appeals. First of all consumer courts are now given the power of reviewing their own orders within 30 days, and this can be done even suo motu. Parties can apply for review, or if the court sees that there is some infirmity or defect in the order, then court can rectify the situation on its own also. Then coming to the appeals, if your complaint was in a district consumer court, which means that the first case you filed was in the lowermost consumer court, the district, then district, suppose judgment is passed, district to state appeal is 45 days, and all other appeals are 30 days. So state to national, national to supreme, and CCPA order to National Commission appeal, all others are 30 days. District complaint to state appeal is 45 days, all other appeals are 30 days. And for going in appeal, the pre-appeal deposit is 50% of the decretal amount. Now, my dear friends, Consumer Protection Act has a lot of extra provisions, a lot of extra offenses which the consumers can take advantage of. Consumer courts give extra provisions and these extra allottees which are very, very useful for the allottees. First, there is deficiency in service. What is deficiency in service? In short, any kind of shortcoming or negligence or omission and even deliberate withholding. It is very common that promoters deliberately withhold information how much are the expenses incurred, what are the true expenses that have been incurred, what is the status of society formation, what is the type of material used. So it is not just any kind of defect or deficiency, it is even withholding of information. So this deficiency in service is, I will say, the second or third biggest offense in the consumer courts. Then there is restrictive trade practice. Restrictive trade practice is basically manipulating the delivery or the price or something that has caused a delay to the service of the goods. So what that translates in real estate transactions is intentionally not giving you possession, is intentionally delaying society formation, intentionally delaying conveyance, and all this has led to a rise in price. Sometimes we will say that because of his own delay, because the promoter's own delay, the price of the price of the flat has risen, the maintenance amounts have increased, the stamp duty on the flat has increased. Possession was promised in 2018, but now 2021 possession is being offered, and you claim in the consumer court that, my lord, if he had given in 2018, I would not have to pay such a 2021 ka rate ka stamp duty. So cost escalation of stamp duty, cost escalation of the price of flat, and stamp duty not just for a flat, stamp duty even for conveyance. If promoter is doing the conveyance proceeding, especially under deemed conveyance where society is bearing any portion of the stamp duty burden, then restrictive trade practice provisions can be invoked. There is a very fixed period for granting conveyance under the either MOFA or under RERA, and you show the court that, my lord, calculating this formula, say it was to be granted on X date, but finally conveyance is being offered, say 2 years after the X date, and, my lord, there is a cost escalation of stamp duty on that, and the cost escalation should be borne by the promoter, not by the society or by the allottee. And my dear friends, you can keep in mind that for all matters in the consumer court, you are entitled to get compensation. So let me deviate 1 second, then I will come back to the point. Many society disputes, a member of society versus society, compensation is granted. So practically for every matter, you can claim compensation in the consumer court. There is deficiency in service, unfair trade practice, restrictive, all these offenses which I will show you, claim compensation, heavy compensation on all these points. So there is a cost escalation, you pay the price rise, to that kind of order you can get, and heavy compensation on top of that. So this was offense number 2 under the Consumer Protection Act, restrictive trade practice, that price or delivery is manipulated and there is a delay or there is some cost escalation. Then unfair contract. My dear friends, do not underestimate the importance of this unfair contract provisions in consumer. See, RERA also saves the allottee from unfair contract. But what I have observed is that it is not the tribunal which protects the interest of the consumer in unfair contract, whereas the RERA authorities, they go by the plain reading of the agreements, that if this is the agreement, this is the contract. So RERA Act actually lacks a definition of unfair contract. RERA unfair contract judgments are more or less borrowed from consumer. In unfair contract is a new definition under 2019 consumer, but unfair contract even under consumer, it was well settled that consumers are protected against one-sided unfair contracts. And those principles, those judicial precedents have been borrowed by RERA in the very initial days of RERA. But the point here is that RERA does not have a strict definition of what is an unfair contract or one-sided contract. Consumer Protection Act very squarely defines what is an unfair contract. It is again an inclusive definition, so any new type of unfair contract, it will be brought within the purview. And let me show you what are examples of unfair contract as defined in the definition clause. First of all, it is defined as a contract having terms which cause significant change in the rights of the consumers. So you can see such a wide interpretation is left. It is not called something like that, is something that is agreed and then it is changed. It is presumed that things are agreed and something has changed, and this change is not beneficial for the consumer. So there is such a strong presumption in favor of the consumer. It significantly changes the rights of the consumer. What will be the effect of this unfair contract? Those unfair terms and conditions will be declared null and void. My dear friends, it is not the whole contract which will be set aside. It is only that particular clause which will be set aside. Before I go into what are the examples of unfair contract, let me also say that RERA, when it talks about unfair contract, it only in the RERA Act, it only and only talks about agreement for sale having an unfair contract or unfair clause. But under consumer, even your allotment letter is counted, even your conveyance deed is counted, any type of contract is counted, and in fact, even if one letter is sent to you by the promoter sends one letter to the allottee, and suppose that letter intends to operate as a contract, like that letter changes a right, consumer court will not look at it, oh, this is a letter, this is not a contract, so we will not look at it. That will not be the ground. Even if one letter is sent by the promoter to the allottee and it changes the rights, consumers are protected. So it is not just the agreement for sale which is an unfair contract. All letters, all deeds, conveyance deed, allotment letter, booking letter, all A to Z documents can have unfair contracts. Now, what are the examples of unfair contract under the Consumer Act? Number one, it says manifestly excessive security deposits. So, for example, you pay the gym or clubhouse membership fees today, but that gym will be functional only after 2 years. Then why are you making me pay the membership fees now? That is unfair contract. Then unreasonable money or obligations are imposed. So, for example, suddenly the promoter is demanding extra money which is not as per schedule, and it says that you pay this money or else we will charge you interest, or you pay this money or we will terminate your allotment if you don't pay. So unreasonable money or obligations is imposed. So it's not just money, even some kind of obligation that you come for the stamp duty immediately, even though you have some kind of dispute with the promoter. So unreasonable money or unreasonable obligations which put the consumer at a disadvantage. And similarly, in the same example, if he threatens termination, unilateral termination or unfair termination, then that is an unfair contract. Then disproportionate penalty for breach is an unfair contract. What is disproportionate penalty for breach? You open any promoter's agreement for sale, 99 out of 100 promoters will have this clause that if promoter breaches any of penalty for breach of contract, right? So promoter breaches any of the terms and conditions, promoter will pay a nominal 6%, 9% simple interest penalty. But if allottee, the flat purchaser defaults, he will pay 21% compound interest, compounded quarterly. So disproportionate penalty for breach of the contract is an unfair contract, and there have been many consumer court cases where the courts have held you have tried to levy higher penalty on the allottee. So dear promoter, Mr. Promoter, you will be levied the higher penalty. So consumer courts, it is very common, very normal that this unjust penalty is in turn applied on the promoter. So unfair contract example is disproportionate penalty. Then refusal to accept early repayment of debts. It is very common that appropriation is disputed. That promoter is making a demand and allottee disputes that ground for demand, and allottee makes payment either under protest or allottee says you please appropriate it to so and so category, that this is not for your purpose, this is for this purpose what this payment should be appropriated to. Suppose promoter rejects that payment saying that no, if you are paying for this I will not accept, I am going to reject your payment, check is not deposited, check is returned. So refusal to accept early repayment of debts. Deliberately promoter is not accepting the payment of the price. So that is an unfair contract. And the last example given by the definition clause is permitting assignment of contract to a third party without consent. Now in real estate transactions, in real estate projects, it is very normal for the project to change hands. It goes from one promoter and that promoter sells his project, or he does a joint venture with a third party promoter, and till now many times allottees are not even bothered to be informed. Promoter X or promoter A has been sending on the correspondence and demands till now. Suddenly one fine day promoter Y or promoter B is saying you make the payment to me now onwards. And many times it so happens that when this project and joint venture is done, the incoming promoter, he changes the terms and conditions, or he changes the flat or the amount or the carpet area or something, and allottees now are protected against this. So permitting assignment of a contract to a third party without consent means that the promoter cannot enter into joint ventures or partnerships without consent from the allottee. Now, luckily, RERA also has this provision that if you are entering into any joint venture, you upload the agreement on the RERA website. So similar, this is a counterpart to that provision. This is a consumer counterpart, and using this, you can claim compensation that he has assigned to a third party without my consent, and I am entitled to compensation. Now, why this unfair contract provision is important, my dear friends? It is not just that it is a strong provision. Give me just 1 second, please. I'm sorry, I'm sorry. So I was saying that it is not just that this provision is strong, that is why it is important. The importance of this unfair contract provision is that even if one allottee in the project obtains an unfair contract order, keep in mind the consequence. It is a domino effect, it is a chain reaction. If one allottee obtains, all the allottees in the project can one by one claim that benefit of that unfair contract order. So, what is an example that some charges were levied and it is said that consumer court has said, no, this charge is an unfair contract, so all allottees will get refund. Not forming society and compensation was granted. All allottees can claim the benefit of that granting compensation. So you can just imagine, my dear friends, what is the potential of this unfair contract. Whatever promoter does wrongdoing with one allottee and that one allottee gets benefit, everyone in the project can get that benefit, but more importantly, that benefit can be used even across all the phases of the project. Number two, it can be used across all other projects of that promoter. He is doing this wrongdoing, this unfair contracting in one project, and he is doing this similar unfair contracting in another project. Those allottees can also benefit. And my dear friends, thirdly and most importantly, one such unfair contract order can even have the potential of impacting the whole country or industry. So when consumer court passes one order that this kind of thing is an unfair contract, deliberately not forming society, deliberately not selling the flats, it is such a normal case that deliberately flats are not being sold, and the promoter is deliberately not selling the flats because he wants to get a better rate later, and promoters letters refusing formation of society, etc. If one unfair contract of any nature is there, it can prevent the wrongdoing in the whole country, in the whole industry. But such type of practice is now not allowed to be done in the real estate sector. So unfair contract benefits are very vast that should not be underestimated. Then next, my friends, I said that misleading advertisements. To protect misleading advertisements in the whole consumer sector, benefit is given to the allottees also. What is misleading advertisement? It falsely describes that service, or it misleads by some kind of implication, or it misleads as to the nature or the guarantee, etc. And even implied, not express advertisement, but even implied advertisement. In one or two next slides, I will show you. So misleading advertisement definition is also very wide. Then there is unfair trade practice provision. Unfair trade practice is the biggest definition, biggest offense under the Consumer Protection Act. In short, anything that he does wrong or unfair, that is an unfair trade practice, including things like not issuing the cash memo. The Consumer Protection Act provides a format for issuing a bill, a receipt. When payment is made and receipt is issued, a format has to be issued. Like for example, we have some cases going on where we are disputing the amounts that they are collecting and the receipts. They are not disclosing the correct facts of the case. It seems that they are charging us for things that are not allowed, and that is now pursuable under the Consumer Protection Act. that what is the particulars you are charging me for with the taxes, and that it is not applicable. You are not charging me for any other allottees expenses. It is also unfair trade practice to give false representations about the trade's quality needs. So if promoter says that you need this to get your flat, say you have to pay this charge or you have to carry out this construction, and if it is found that it is not actually necessary, it is just a wrong thing that the promoter has said, it is included in the definition, and there can be compensation and the wrongdoing will be fixed. Also, my friends, included in the unfair trade practice definition is many times there are offers that first 100 allottees or first 100 flats will be given the benefit of some discount, etc. So many times schemes and offers are there, and allottees are assured to know the results of that scheme. So promoters cannot now do this thing that they will give some kind of discount saying that first 100 allottees, but actually this first 100 thing doesn't exist. It is just some advertisement to incentivize the allottees. Now allottees can write to the promoter saying that you show me who are the results, what is the result of your offer, what is the result of your scheme, and if promoter does not disclose that, then you can take the promoter to court that see he is doing a wrongdoing kind of an offer. It is a fake offer kind of a thing he is doing. He is not, this is not a real offer, and he is not giving me the results of this offer. So that is also under the definition of unfair trade practice. Now, my friends, another offense is violation of consumer rights. You can go through the definition, but what is the essence of this violation of consumer rights definition? It puts a very supplementary and persuasive obligation on the promoter to maintain healthy communication and healthy business relationship with the allottees. Violation of consumer rights means consumers have rights to know the true materials and the true facts of the case, the true market picture scenario, the true construction details. So when allottees have any grievances, any queries, this provision puts an onus on the promoter to comply. So these are the extra provisions, extra offenses under the Consumer Protection Act. Now, my dear friends, now comes the main topic of today. What are the analysis of the pros and cons between consumer and RERA? First of all, let us talk about the investigation powers during the ongoing pendency of the court case. See, like I said, RERA investigation power is limited to the promoter, allottee and agent. That is what the statute says. Still, MahaRERA has to protect the allottee. Many times it has called the architect and engineer, and it has called the architect and engineer in some cases. But it seems that the parties cannot ask this as a matter of right. It cannot ask for this investigation as a matter of right. And it is more discretionary in the hands of the authority. But under consumer, this investigation power is very, 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 very strong. The parties can be called, the relevant parties, even third parties can be called if it is found that this third party is necessary to dispose the matter, to find out the correct facts of the case. Third parties can be called, and even government officials can be called to the consumer court to give their testimony, to give their information, or to even give evidence. Consumer courts can also, just like the CCPA, do raids, search and seizure to obtain information and to determine the evidence. So when there is a risk of evidence tampering, papers are going to be destroyed, digital records are going to be manipulated, or some kind of lies has been spoken by the promoter that the dues have been cleared, application to government has been made, all kinds of submissions by the promoter. If it is found that he is lied to the allottees, or if it is found that there is a risk of evidence tampering, consumer court can do this raid, search and seizure, not just to find out information, but to preserve evidence. It will confiscate what is necessary to be confiscated to preserve the evidence and to carry out the investigation and the court case. Then in today's day and age, advertisements are carried out in a number of mediums, radio, television, newspaper, wherever it is electronic mode, not just advertisement, but many times builders at their websites, they will display something, and if they are not able to deliver it, they will edit the website and they will remove it from the website. Some allottees, they take screenshot, but other allottees do not take screenshot. So this website and thing, amenities thing is just one example. The power given here is that electronic service provider can be called upon to give testimony in the court. Has something changed? Did the website actually mention this, or did so and so feature actually exist on the website on so and so date? Say 2 years earlier, Alotti says he saw this. Call the electronic service provider. Who is the person who is maintaining the website? Is it the builder's in-house department, or is it some third party IT company, some website company, programming company, coding company? Call them to court, determine the correct facts of the case. So this electronic service provider and e-commerce rules will protect all the digital investigation. And just like the CCPA, experts can be consulted, architect, chartered accountants, engineer, anyone can be contacted to find out their expert opinion. What is the quality of construction? The promoter takes this time, but the allottee takes this time. Which of the two is correct? Let the expert decide. And laboratory testing powers are there. That if the goods quality material is inferior, or if it's a bad quality, bad workmanship, it can be sent to the appropriate laboratory to find out whether this is premium quality or bad quality. So in this aspect, in the investigation powers, when you need a detailed preservation of evidence and detailed investigation, it seems consumer has the upper hand. Now, consumer also provides that you can file a court case in your local territorial jurisdiction where you are having your residence or where you are having your office. So, for example, if your flat is in another state, I will give you 1-2 examples. Suppose you are living in Mumbai, but you have bought a vacation home or a village home in, say, another state in Gujarat, Madhya Pradesh, and the property is in another state. Under consumer court, you can litigate from Mumbai. So Mumbai court will determine, Mumbai court will litigate on your Madhya Pradesh and Gujarat property. Why? Because consumer has that provision that consumer complainant can litigate from his local jurisdiction. Another example I will give you. Your residence is in Mumbai, your flat which you have purchased, the new flat is also in Mumbai, but since 2, 3, 4 years, your company has sent you to Kolkata for some work. And suppose you are the main person in your family, you handle all the paperwork. Suppose other family members are not the main people, and you are in West Bengal, Kolkata, but the property is Mumbai. You can file in your local or local residence or local office jurisdiction. So sitting in Kolkata, you can file a case in Kolkata for your Mumbai property. So if your flat or your property is in another state, in consumer court, you can file in your local area jurisdiction also. Whereas under RERA, you will obviously have to go under the state, the RERA state where the property is situated. So this is about territorial jurisdiction. Next, my lord, next, my dear friends, when we litigate or when we have to decide which court to litigate under, we have to see that the court should be in a capacity to examine all the issues. What is the type of the dispute? What are the applicable laws? Are there any peculiar facts? Are there any mitigating circumstances? So what is the example of that? Suppose society also has to be penalized. Suppose you have to file a case, allotee is filing a case against builder as well as society, because society is hand in glove with the builder. It is doubtful whether RERA will pass such orders against the society or against the chief promoter or against the managing committee. It is doubtful whether RERA will pass directions, and it is very, very doubtful whether some kind of compensation or penalty will be imposed on these people. Consumer courts are very well in the position to penalize all these people. So consumer court is in a position to analyze all these defects, that yes, the managing committee has been negligent, yes, the chief promoter has been negligent, yes, the society itself has been negligent. So there is no doubt that consumer court can pass such orders. There is some doubt whether RERA can pass such orders. So similarly, you have multiple issues. Suppose it is a possession delay, society formation delay, and conveyance delay all at the same time. In consumer, in one court case, you can file against society and builder, and in one court case under one roof, in one proceedings, you can finish off all the issues. whereas RERA will only entertain with regard to the allottee and promoter and the typical stereotypical grievances. So if there are any peculiar facts and circumstances, RERA may be reluctant to pass a penalty on the other third party wrongdoers. And under the same principle, the grievances against third parties may be totally not maintainable under RERA. So RERA may pass an order that if the complaint is not maintainable against so-and-so parties. So another example is, suppose you want to implicate the bank also, that some order has to be passed with relation to the loan or some kind of encumbrance or mortgage, and RERA may or may not entertain such a complaint saying that bank has no jurisdiction or locus standi, RERA cannot pass such orders against the bank. It is doubtful if the matter gets so niche that strong orders have to be passed against bank also, suppose the bank's mortgage has to be cancelled, etc. Then consumer courts are 110% within their powers to grant such orders. So we have to say what are the due consideration of issues, and if there are any niche kind of issues. For example, promoter has to fix the title and then he has to give conveyance. Under MOPA, that was the requirement that the promoter first has to fix his title and then he has to pass that perfect title to the allottees. Now that provision is not there in RERA, but still consumer court, I am 100% sure, will grant such orders that you perfect the title and sell it and then give the conveyance, because the consumer definitions are so wide, whereas RERA might just say you comply with the section and you comply with the contract. So due consideration of issues, the professionals should analyze, are there any niche or specific or specialization reliefs that have to be granted to the allottees. Then my dear friends, let us examine how these special offences and provisions of consumer can protect the allottees. So there is restrictive trade practice. So price escalation in case of the cost of flat or in case of maintenance, that price escalation can be claimed from the builder. Sometimes there is the escalation in the stamp duty or property tax or water tax for the flat. OC is not received and there is penalty on water tax, etc. So that excess you can claim from the promoter. Then there is a price escalation in the stamp duty for conveyance. Then that escalation you can claim from the promoter. Restrictive trade practice also covers bank EMI. Possession is not delivered, but I am still paying EMI. So that EMI you can claim from the promoter. And under restrictive trade practice, you can also claim from the promoter expenses which the allottee has incurred. Advocates expenses had to be incurred, chartered accountant expenses had to be incurred. If it's a carpet area dispute, I had to hire an architect for the measurement of the flat, and that expenses have to be reimbursed. I had to appoint some kind of consultant for the flat, some kind of contractor or some kind of municipality. I wanted to do my due diligence and I had to appoint an expert consultant. All these professional expenses which the allottee have incurred, they can be claimed back from the promoter in the consumer court case. So these are the various advantages of the restrictive trade practice definition. Then under unfair contract, all your arbitrary one-sided clauses will be tackled. So charges are levied, flats are cancelled, conveyance is delayed, society formation is delayed, some arbitrary obligations are imposed, arbitrary time limits are imposed. All these are unfair contracts, and manipulative tactics will be tackled. Non-consensual transfer of project will be tackled. Like I said, one unfair contract order benefits all allottees in the project, all phases, other projects of the promoter, and even the whole industry. This is the advantage of unfair contract provision. So I will repeat, unfair contract is defined under consumer, it is not defined under RERA. Misleading advertisement provisions, like I have said, that they are very, very strong. In today's day and age, radio, internet, mobile, billboard, hoarding, brochure, newspaper advertisements are there. And RERA defines advertisement, but consumer defines misleading advertisement. So there is an express offense, express definition, express parameters as to what constitutes a misleading offense. So they may not be allowed to take advantage of any gray area or loopholes. Also, what is included in this misleading advertisement? Some kind of implied thing, like I said. So for example, he wants to market his thing as very wide open spaces, and he puts in this advertisement like some kind of large trees or some kind of large compound is there. But when you actually see the site, it is actually a very small portion. So you can take this misleading advertisement to court and you can tell that, my lord, this advertisement, it implies that, my lord, just look at how much area he's advertising in the project. It seems like such a large square meter. It seems like, just to exaggerate, 1,000 square meters open space is shown in the advertisement, and it is implying I will get this much, but hardly 100, 200 square meter open space is giving me. So even some kind of necessary implications which the advertisement does, that there will be lots of greenery in the property, but you go to the site, there are 2-3 trees in the actual vicinity, whereas the advertisement shows that the site is full of trees. So even if something is being implied in the advertisement, you can take advantage of that, and just for unfair contract order you can set off a chain reaction. Even misleading advertisement, you can set off a chain reaction. So he has advertised something, one order is passed that so and so is a misleading advertisement, circulated amongst the allottees, and they can all litigate on the same. So even one misleading advertisement order, it can benefit all the allottees. Then unfair trade practice, like I said, it is the biggest type of wrongdoing. So in this, every type of wrongdoing conceivable will come in unfair trade practice. What the definition also expressly holds as unfair wrongdoings, like I said, sometimes there are schemes and offers that first 100 flats or first 100 allottees will get a discount. Sometimes there is a lottery system. So sometimes they say that stamp duty registration free for the first 100. You are entitled to write to the promoter saying how many of them are done, what was the start date of the scheme, what was the end date, how many people benefited from this, what were the details of this, you tell me. And if he does not tell you, you can take him to court saying this is a wrong scheme, this is a fraudulent scheme that he is coming up with, and it is an unfair trade practice. Next is some kind of compulsion. Like I said, he says so and so is compulsory for you to get the flat. So and so charges are compulsory. For example, he says you have to pay so and so charges are government taxes, but actually that is supposed to come out from his own pocket, or that you have already paid that component, or something is not compulsory, it is a voluntary charge, or it is a voluntary permission. If it, but he falsely represents to you कि नहीं ये compulsory है, इसके बिना project नहीं चलेगा, इसके बिना possession नहीं मिलेगा, इसके बिना OCBCC नहीं मिलेगा. If he says that wrongly, that is a unfair trade practice. Falsely saying that something is compulsory. Then false implications, just like advertisements, some kind of taglines are there, photographs are there in the advertisement, or they say that we are member of some kind of prestigious affiliations. Say they are with MCHI Credit, and we say that we are professionals of MCHI Credit, but they do bad construction support. So they have sought to encash on the goodwill of some kind of affiliation or Bureau of Indian Standards or some international grading system or some kind of affiliation or grade. So they falsely imply that we are of a particular value and we will give you some kind of quality material. So that is unfair trade practice. Then what is also unfair trade practice expressly in the definition? Price is different from advertisement. They can obviously put asterisk, but case to case basis, it is very much possible that that is still coming within the purview of wrongdoing. But if so and so is the actual price of the flat, how dare you can advertise it like that on the billboard hoarding advertisement. Then refusal to terminate, refusal to refund, that is an unfair trade practice. Guarantees and warranties, when they are giving but not living up to, that is an unfair trade practice. And like I said, there is a prescribed format for issuing the payments. So no manipulation can be done in the amounts. If you suspect they are doing some kind of manipulation, you quote it. You quote that the Consumer Protection Act rules, they require that the invoice is supposed to be issued in so and so, and you kindly clarify what you charged me for. Kindly clarify what you have appropriated it me for. Give me the narration. Give me the breakup. If you are charging this as a total, you give me the detailed breakup. The prescribed rules provide you with that right. So these are the unfair trade practice provisions. Now under consumer courts, what is one very big and dangerous thing for the promoter is to become habitual offender, and because of habitual offender, their penalties will increase and the risk of imprisonment increases. Now what is habitual offender? It means that for the first time, if you are doing some kind of offense, X penalty or imprisonment will be given to you, but habitual means subsequently higher and higher penalties will be granted to you. So under RERA, usually I have seen the same quantum is granted. It is only in a handful of cases that the adjudicating officer, they say that this has been repeated, that is why we will levy higher penalty, and even the higher penalty seems to be only of the threshold of 1 lakh compensation. Whereas under consumer, the compensation component is higher. I will come to that later. But what are the criminal provisions under Consumer Act? So first of all, if the promoter does not comply with consumer court cases, there is criminal execution. He can get 25,000 to 1 lakh, and he can get imprisonment up to 3 years, 1 month compulsory imprisonment in criminal execution. At this point, let me take the opportunity to tell my dear friends, consumer has two types of execution, civil and criminal. RERA only has civil. Under consumer criminal execution, it is treated like a full-fledged criminal hearing. Promoter has to appear every hearing. If he is not coming, he has to give an exemption application. There will be a warrant sent out for his arrest. He will have to take a bail. It will come on his criminal record, and he automatically risks becoming a criminal habitual offender by criminal provisions under consumer. So first way of criminal under consumer is criminal execution, because consumer court order has not been complied with. That is the penalty and compulsory 1 year imprisonment. Then CCPA order is not complied with. So the fine can go up to 50 lakhs and order can be passed to stop advertising your project up to 3 years. So every time this offense repeats itself, the penalties will be higher. Then there is non-compliance. So number one is that CCPA order was issued. Number two is that CCPA order is not complied with. So there is further contravention penalty up to 20 lakhs fine, up to 6 lakhs imprisonment. Can you imagine, my dear friends, criminal execution as imprisonment, the CCPA order non-compliance as imprisonment, and for misleading advertisement, additional heavy penalty is granted. Up to 10 lakhs is compulsory, has to be given, and if they do not comply with that, the last category I'm talking about, section 89, compulsory 10 lakhs is there, and if they do not comply with that, compulsory additional amounts are there up to 50 lakhs. So 10 lakhs, section 89, it can give penalty under in addition to all the earlier. And if this 89 is once again not complied with, it will go up to 50 lakhs. And the section 89 uses the word punishable with this fine and imprisonment. So there is compulsory imprisonment in the section 89 orders also. In the first instance of it, it is up to 2 years, and under contravention, it is up to 5 years. So my dear friends, can you imagine such 5 years jail, such 50 lakhs penalty, such 3 years stop advertising? It hits the promoter, but also it risks of him becoming a habitual offender. One allottee goes to the court and gets any of these violations, then second time any other allottee, he goes to the court, and if the promoter does not comply, the heavier penalty will apply. The allottees can coordinate amongst themselves and they can tell the court that, my lord, in my case, this penalty was imposed, so in this case, higher penalty should be imposed. And it is very easy for doing not compliance. When such orders are passed by the CCPA or by the consumer courts, say you stop the misleading advertisement, you issue the refund, or whatever order is passed, and you stop this advertisement or whatever, and it is very easy that promoter is not able to comply it. So suppose there are 10 allottees cases, and all 10 cases such orders are passed. Let the first allottee put in execution, let him get the habitual offender penalty, and then let the subsequent people file their case one by one. So in their cases, when promoter is still not complied, higher penalty will be put on the promoter. So you can imagine, my friends, under consumer, the advantage, the pro is that risk of habitual offender and the threat of imprisonment is a very real threat. Then now comes the main pros and cons. Everyone is not concerned with all that. If your court case is not getting over on time, all those other provisions are absolutely meaningless. So let us analyze what is the time taken for disposal. RERA has done a very fantastic job coming out with this circular that no more than 2 adjournments will be granted. So by this, automatically all the RERA matters will get disposed very, very fast. It is definitely one of the best ways forward towards RERA disposal. What are the counterparts of consumer for disposal? Approximately, I have observed that if you do everything properly, you don't get sucked in by the delay tactics. Approximately within 1 year, you can get your justice in the consumer court. You just be aggressive enough. In consumer, the best, like one of the good advantages is that your matters are listed very, very early. If you file today, in most consumer courts, on the spot they give you the first hearing date, the admission hearing date. And even if that is not given, within 21 days, there is deemed admission and you can proceed with the matter. Whereas under RERA, it seems that at least it was until 2-3 weeks ago, getting the matter listed was a problem. So let us see if that trend changes. If RERA lists the matter also very quickly, then it is no doubt that RERA matters will get disposed very, very fast. So if RERA is able to list the matters quickly, then it will be the faster of the two forums. So those are the provisions for disposal, and I may also add that under consumer, maximum 45 days time limit is given to the promoter. So 45 days is actually, it can be a very short time if the complainant consumer files a court case which is very bulky and voluminous. It can become very difficult to file a reply within 45 days. So that aspect may also be considered. Then next, talking about disposal, execution of orders is also an important concept. If order is passed but it is not being complied with, then what is the use of that piece of paper? Under consumer, civil and criminal executions, both provisions are there. Civil execution gets over within 1 hearing. These execution proceedings also, when you file with the consumer court, immediately they give you the hearing date. Civil execution gets over in 1 or maximum 2 hearings. There is no defenses which the promoter can take because the law does not permit him to take any particular defenses. Recovery certificate is issued within 1 or 2 hearings in civil execution in consumer courts, and in criminal, like I have said, it is a full-fledged criminal hearing. There are bail provisions, there are imprisonment provisions. So under consumer courts, there is a very real threat of imprisonment and taking the order seriously. And also talking about disposal, it might be a small factor, but when the matter is complicated or when matter is going to go for a long time, it is worth noting, it is worth knowing that consumer court has its own website which in detail lists out the roznamas and daily orders. You can see very much in detail what were the orders passed by the courts from the first hearing to the last hearing. So suppose matter is going on since a long time, it is very easy for you to understand the brief because all the roznamas are online. Whereas under RERA, if some order is passed that party has to make some compliance or chances given but not complied, so that chance is gone now, that chance is not going to be given. The professionals might be in the dark, might be ignorant of such orders that may have been passed by the authorities. Under RERA, the Consulate website, detailed roznamas are passed, and I am sure that in the coming few years, through trial and error and through experience, RERA or MahaRERA may introduce this roznama system. Then my lords, then my friends, talking about compensation. When allottees get relief, they also, not to say that they get greedy, but they have suffered so much, such amount of bullying is done to the allottees, such amount of headache and hardships are faced, that they say that, dear advocate, I want heavy compensation. Now, what is the trend of RERA? Typically, I have seen 20,000 costs are given and 50,000 is the average compensation in RERA, and 1 lakh I have seen in exceptional circumstances adjudicating officer passes the compensation. So that is the average in RERA. Whereas under consumer courts, you open the consumer court website, you analyze any random housing judgments, you will see that 1 lakh to 2 lakh is the bare minimum average. Consumer court grants lower compensation for housing also 20,000, 50,000, but these lesser are very, very less under consumer. It is very normal, usual and frequent. Consumer courts will pass 1 to 2 lakhs, even 3-4 lakhs as compensation. Not just, consumer courts will pass refund with interest order just like RERA, but compensation component is usually much higher. And like I said, my friends, under those definitions of consumer, you can claim back all the expenses which you have incurred, bank EMIs, professional expenses. Allotee is entitled, allowed, and it is very much so done that the amounts are granted to the allotee. The amounts which the allotee has spent are granted to the allotee. So in that aspect, consumer court is very liberal in reimbursing these amounts. Also in consumer, there are established principles. There is a principle in consumer code that these damages will be calculated according to the principles of compensation which have been formulated under the breach of contract component of Contract Act. Now, in short, what these principles say, bigger the wrongdoing, bigger the compensation. So if the act of the promoter violates deficiency also, unfair trade practice, restrictive, violation, misleading, the consumer court will come down very, very heavily. And most of the times it's not just the type of, not just the definitions of offenses. As we saw in the grievances about possession delayed, plans are changed, conveyance, society. When there are multiple on those fronts, also multiple violations of these offenses also, and multiple violations of substantive provisions also, consumer court comes down very, very heavily. And in cases of conveyance, cases of societies and all, 7 figures compensation are passed, 10 lakhs and onwards compensation are granted by the consumer courts. So what the court observes is that the bigger the wrongdoing and the longer the wrongdoing, the heavier compensation you get. Under consumer courts, definitely compensation component is higher, and similarly even the interest component is higher. Now RERA does not have a discretion or option. RERA is compulsorily bound by the interest formula, the SBI rate plus that 2% of SBI lending rate plus 2%, whatever is the formula. Consumer court is not bound by this formula, and consumer court is at full liberty to grant whatever interest percentage it deems fit. 12%, 18%, even 21% in some of the cases consumer courts have granted. So that is one advantage which consumer courts may have over RERA, that the compensation and interest may end up being double of RERA. Then comes the consideration that what is the length of the appellate process. That ठीक है, रेरा का तो ऑर्डर आ गया अलॉटी के फेवर में, लेकिन अपील में जाके स्टे आ रहा है, and it is as good as stuck. The matter, it is as good as null and void. The results, there are no tangible results. So let us analyze what are the appellate provisions. Under RERA law, compulsory all 3 matters of appeals are there. You cannot reduce the number of appeals. So there will be RERA or AO orders, then there is a tribunal, then there is High Court, and then there is Supreme Court. So original and 3 appeals, compulsory it is there. But in consumer, there is a very good chance that 50% of the cases might have less than 3 appellate processes. So you will have 3 appellate process in consumer only if your complaint is a district commission complaint. So district commission complaint, district consumer complaint, appeal to state, appeal to national, appeal to Supreme Court. But that also, appeal from state to national is only one point of law, just how second appeal is under RERA, and national commission to Supreme Court or state commission to Supreme Court if there is no point of law. That is also under special leave petition, and both these under RERA and consumer are very, very discretionary and narrow. But under consumer, if it's your state commission complaint, if you have paid more than 1 crore, if the allotee has paid more than 1 crore consideration paid, it is only the national and Supreme Court. So the time taken in the appellate process, one court is eliminated altogether. So if it is a state commission complaint, the length of appellate process will be very, very slow. And in consumer, the appeals are dealt with very expeditiously, very summarily, and very, very quickly. Hardly 2-3 hearings will be there, and the matter will be disposed of. Many times in 2 hearings also, it is disposed. That in first hearing notice is sent, second hearing replies filed, arguments are done, everything is served in advance. Court is also informed that my lord, everything, all the parties have been served well in advance. Kindly move for final arguments of the matter. Hardly 2 hearings, the matter will be disposed of. And National Commission and Supreme Court, I have myself experienced it. It is very simple to get the matter disposed of very, very quickly. So length of appellate process might be a very valid consideration in determining which court to go under, and especially considering that High Court may be burdened, High Court may take at least 1 year sometimes, and that also if stay is granted by the High Court or stay is granted by the tribunal and it is not being vacated, or stay is granted and there is tarikh pe tarikh, then the allottee may be agreed to that extent that injustice has been done to us, that he got a stay and now matter is being delayed, now matter is just lingering on in so and so forth. Under consumer, that chances is very much less. So this is the consideration of the length of appellate process. So my friend, that is the end of all my pros and cons discussion. Let me end on this note saying that at the end of the day, you can use both provisions and both the codes. Even you can go to RERA and you can highlight the consumer code provisions that, my lord, the consumer is an allottee, the allottee is a consumer, and the allottee is entitled to various protections under the Consumer Protection Act. Go to RERA and plead consumer provisions a little persuasively. No need to harp upon that. Make it a secondary or persuasive argument, especially considering the fact that when RERA was new and when tribunal judgments and Nilkamal judgment and the authority judgments, they have borrowed a lot of principles from the consumers, unfair contract principles which are established by the consumer courts and the protection of consumer principles. A lot of them were borrowed because RERA was a new law and the principle was protection of the allottees. So the conclusion, let me just end on this note saying that it's okay, you plead RERA provisions in consumer and consumer provisions in RERA. Both laws work in tandem, both laws supplement and supplant each other, and they are coexisting with each other. So with that, I have reached the end of my talking. We can take up questions if there are any questions.
Yes, Mithil sir.
Yes.
First of all, very great and informative session. I myself have two questions which I have written during the session, and so first of all, the most important point that I understood from this discussion is about the unfair contracts, the principles that are established by the Consumer Act and which can very well be used while pleading our case in front of RERA authority. So this is the thing that I understood, which is the new learning that I got from this today's session. Second is the meaning of forum shopping. I was under impression that once you have filed a complaint with the RERA, you cannot file the complaint with the consumer forum. But yes, with the way you told us, that I came to know that consumer forum, you may have some other reliefs in consumer forum, and some other reliefs you may file a case with the RERA. So forum shopping का जो meaning है, that concept got much clear, because in one of my clients' case it happened, and we didn't wait for, of course, that case was something different. कुछ terrace builder ने promise किया था और वो दिया नहीं, common terrace जो है वही दे दिया, free of FSI जो आता है वो, तो उसके बारे में ये था. तो delayed possession का जो matter है, that was with RERA. So there was some discussion just a year ago going on whether to file this particular matter for terrace with the consumer forum or not, and it was written in the agreement. So very nice session, Sampat sir. We have Dilip Agarwal sir also. Sir, do you have any questions for our speaker?
Sir, no, it's questions and answers both delivered simultaneously.
Exactly. That is why I told him my question and the answer that I got from this session. Both the things I told him. As such, there was no question. So if I'm going through the chat box, if there are any questions, so Atul sir, you can unmute your voice and you can ask your question directly to the speaker. See Atul Purani.
Yeah, Sumit, it's fine. I just practical query is there that both the forums, the alternate remedies are taking too long practically for all of us practitioners. So, I mean, what could be the cause, or is it because awareness is more? Maybe Mithil can help.
At the end of the day, we can also attribute it to the burden of workload for the whole state of whichever state. There are, a few officers appointed. So it is possible that, there is a bottlenecking of the matters, and that is why it is taking time. A handful of officers, and the same officers sit in the circuit benches, the regional benches also. So to some extent, it may be conceivable that it is because of the bottlenecking of issues. But I suggest do not go for conciliation hearings in RERA, because whatever you can do in conciliation hearings, you can do without that formal tag of conciliation also. What is conciliation? At the end of the day, conciliation is simply negotiating that amicably अपने से solve हो रहा है कि नहीं. You can do on phone call, you can do on video conference, you can do by meetings. Why you want a formal conciliator, mediator who will allot a date, allot a case number, write up a report, refer the matter back to RERA? So it is a very good step. And this conciliation, I recommend the client's conciliation forum only when there are a large number of allottees who are having some kind of grievance. So it may be help to streamline the process. Conciliation forum may help to streamline and make it organized, whereas there are a large number of allottees in a project who are having grievance. But if it is a one-on-one grievance, never go for conciliation. And as regards the matter taking a lot of time, to some extent we are at the mercy of the authorities, but another solution can also be file a writ petition in High Court requesting expeditious disposal. And this you can do for consumer court also. You can file a revision petition seeking expeditious disposal.
But Mithil bhai, my query was also about almost we are forced, practically at RERA for conciliation. I mean,
I understand.
that's not fair. But
it is less insisting more of the I understand, sir. That is where the professional and the client have to stand their ground. We will explore conciliation. We will explore settling the matter possibility, but no need to go for mediation. Kindly give us an adjournment, maybe 1 month, 1.5 months. Give us time. We will negotiate, and if we cannot negotiate, we will file a replies, disputes, whatever. Yeah, I suggest that you may kindly stand your ground strongly. Then, my lord, we will try to do, but no need to go for conciliation. Strongly refuse.
thanks.
Yeah, Atulji, my feedback on this, I can contribute here. Atulji, what happened? Many cases they have taken up for hearing only for the purpose of suggesting whether you are choosing to remain in this or you want to go for conciliation. They are now not forcing. There is a specific circular for this, and that circular only give the opportunity you to choose, because what they think, whatever Mithil said, if you choose to compromise with the builder, LOT and builder, then it may be amicably settled and resolved, and number of cases can be reduced from the portal. That is the intention. But they are not forcing. Just they are asking whatever you want, you tell. If you say we can continue with RERA, they are not forcing you.
It was my personal experience. That's why it's.
Maybe in the very beginning it was true. 2 months back it was like that, what you experienced, but thereafter there were lots of presentation with chairperson, and then he came out with the circular, and that's now they are following the circular, wherein no one is forcing you to do whatever you want.
I may also add, sir, that the whole legal practice, right from initial days of practice and all the way to the government authorities who are sitting in the judge's chair, at the end of the day, for everyone, it is a slight trial and error process. So everyone is still working out what is the process that works best in efficiency for the authorities also and efficiency for the allottees also in granting the justice. So at the end of the day, in theory, one thing may appear in one way, and when they implement it, I'm sure the authorities are also learning from their experiences. So I think a little benefit of the doubt may be required in that aspect, that we may also, if we are aggrieved by these stands and decisions of the authority, we may communicate it to them that, my lord, if conciliation is merely discretionary and optional and voluntary, my lord, allow me, I don't want to opt for it. So we can present our views also in such diplomatic ways to the authorities, and we may end up assisting them in formulating the policies. It is trial and error for them also.
Actually, one more question.
Yes, sir. I will read out the question, sir. Issue of unilateral forfeiture clause if challenged before Consumer Forum and RERA. So this is it means that for one cause of action, filed in 2 different courts. So that is not allowed. It has to be withdrawn or it has to be dismissed from one of the courts. Both cases cannot be filed at the same time. Because the cause of action is the single thing that unilateral sure feature or unfair contract is.
So my question, sir,
Yeah.
yeah, actually my question was that how it will be dealt at the consumer forum, any such case you can highlight. And
Yes.
I have seen in RERA, but how I don't have any information if such thing is challenged in consumer forum.
Yes. It has very well taken place. Also, there are some judgments also. Majority of these unfair contract judgments are in the old Consumer Act, the pre-2019 Act. And what was one typical example of unfair contract? I will tell you. One judgment said, the judgment narrated, the judge he repeated the facts and he gave the narration like this. He said that what the promoter did, there was a delay in possession, and when promoter sent a letter to an allottee, you either agree to this 2-year delay or you accept refund at nominal interest rates. So, and if you do not reply to this letter, it is deemed that you have terminated, and we will we will refund you the amounts. The very short time was also given, 7 days was given or something to comply, that within 7 days of receiving this letter, you either accept to the delay with no consequences or you take refund at a nominal 6% interest rate. So the code, then the consumer code said that this is a typical example of an unfair contract where you are doing unilateral termination. You have delayed the project and you are prejudicing the allottee by forcing him to terminate such and by forcing him to take negligible compensation. So that is one typical example that such arm-twisting tactics, and there have been some cases under the new act also where the terms and conditions have been held null and void. I will try to look up those judgments, and if you want, I will try and forward them to you.
Okay. So I'll just, of course, along with this, I'll share one more thing is about the delay, which see Atul sir was talking about. So recently, the what we all have, all are experiencing with the Maharashtra Appellate Tribunal, Honorable Kole Saab got retired, and now only one bench is functioning. So most of the matters which were pending before the bench, consisting Mr. Kole, are all pending. Unless the new member is appointed, one cannot do anything. So that much is the maybe a time which one must give, or maybe a cost for the justice.
कॉस्ट वो टेरवे से मेरे वजह से थोड़ी रिटायर हुए.
That is true, but then we don't have an option. मेरे वजह से रिटायर नहीं, लेकिन मैं अपॉइंट भी तो नहीं कर सकता. So nothing is in my hands.
Writ petition in that regard to transfer the matter, that should work as a remedy. Requesting the High Court with a peer to kindly transfer the matter and to not wait for appointment. Another magnanimous is someone public spirited will find this thing, please fill the vacancy, but that is on a large scale. Something on a
large scale, correct.
From a client perspective, the writ petition prayer can be that kindly transfer my matter and to dispose the matter. Do we have any other questions, my dear friends?
I don't see any question in chat. I may request the members if they have any question, or else we can go ahead with the thanks expression of sir. Sorry, I think I was not audible. With the or else we'll go ahead with the vote of thanks.
No problem, sir.
Okay. No, I don't see any questions. So yeah. So Mithil sir, of course, we do have a, it was a great time with you for last 2 hours. Really, I myself have got some concepts clarified, and very much thank you for enlightening all of us about the intricacies and fine tuning of the matters and differences between the Maharera or the RERA authority and the consumer forum. Honestly, we were not that much aware about the provisions or the of the consumer forum, but today, yes, of course, I can say that I got much more information than what I was having before 4 o'clock today. will be the our institute WRC will be uploading this particular recording on its website, and then from there the link can be posted on a YouTube also. YouTube channel is also there, so accordingly I'll also make you aware once that is done. It may take some like a week, and then it will also be released. So thanks a lot, Advocate Mithil sir, and we expect you again and again in this particular forum for knowledge sharing. Thank you, thanks a lot, and thanks to all the attendees.
My sincere thanks for having me. And I look forward every time CA Institute calls upon me, I will be there to deliver. You can call me 1 night earlier also. You can call me same day morning. You can call me 10 minutes before the schedule also. I will always be there for ICA.
Okay, just before we close this meeting, I just got one message in the chat box from CA Sanjay Adav that actually all doubts were covered regards both forum, especially consumer court, excellently presented. That is what we, great. That is really great. Okay, so have a nice weekend, all of you. Thanks a lot. Bye. Take care.